Hear the Court of Appeals in Michigan Town Session, the Honorable Christopher M. Murray, the Honorable Seema D. Patel, and presiding the Honorable Philip P. Mariani. All persons having business herein drawn near, give attention, and they shall be heard. God save the United States, state of Michigan, and this honorable.
Hey, good morning. On behalf of myself, Judge Murray and Judge Patel, welcome to the Michigan Court of Appeals. This is panel 4 of the court's June 2026 case call session, and we are ready to begin our 10 a.m. session for the day. So before I start, just a few quick reminders or remarks. Counsel, when you come up, please put your appearance on the record. If your clients are in attendance today, please let us know that as well so we may welcome them. Counsel, please keep your own time. I'll do my best to help you with that. And I know we have some cases that are consolidated today. If you plan on dividing time with other attorneys, please, let me know that as well. In cases where both sides are endorsed for oral argument, it's a maximum of 30 minutes per side. With only one side, 15 minutes. And please rest assured that we are very familiar with the cases. We've spent a lot of time with the facts and the law. And we'd ask that you please focus your arguments today on, your most salient points or matters that you think require particular clarification from your briefing. And of course, the questions that we may have for you. And lastly, importantly, because these proceedings are being recorded and will be posted publicly online, please, for cases involving children or protected persons, do not use those individuals' names, but instead refer to them by their initials or another non-identifying way. And lastly, counsel, I will apologize in advance if I mispronounce your or any of your clients' names. Please correct me if I get that wrong. It's important to get right. With that, we look forward to hearing your arguments. So we will call the first case today, which is actually item number 23 on our call. That is Estate of Elizabeth Jordan versus Heart and Vascular Consultants, PC. And those are consolidated cases, item numbers 370206, 370778.
Good morning.
Morning, counsel.
Karen Beach on behalf of defendant appellant in the first matter, Dr. Othman and Heart and Vascular Consultants. I conferred with my fellow counsel yesterday, and the plan is to spend 15 minutes on each of the cases, and we're going to do our own internal split of time in the cases so that we preserve, the appellant format, if that works for the court.
Sounds fine to me. Thanks.
I know.
Thanks for sorting it out in advance. It's always helpful.
Sure. I know we're an add-on, and I appreciate the court and fellow counsel's accommodation of my scheduling conflict. So we're gonna keep it to 30 minutes.
You got to be there, counsel. Happy to help.
I appreciate that. So in this first matter, there's only one alleged breach of the standard of care at issue, and that's the cardiologist's failure to recommend that the ophthalmologist perform an eye surgery at a major medical center rather than an outpatient surgery center. So as we set forth in the brief, it's undisputed that the ophthalmologist, Dr. Watson, did not have admitting privileges or any ability to perform this eye surgery at any major medical center. In turn, she could not have done the surgery at a different place, even if my client, Dr. Othman, had wanted her to or suggested that to her, as is the allegation. And what I found interesting as I reviewed the plaintiff's expert, Dr. Fintel's testimony, is there's no allegation that Dr. Othman should have found the plaintiff a different ophthalmologist who did have such privileges and could have done the surgery somewhere else. In fact, he agreed that the decision on where to perform the surgery is made by the eye surgeon who wasn't sued, and that's at page 131 of his deposition. He goes on to say that a recommendation to do the surgery elsewhere would have been good medical practice, but the standard of care doesn't mandate that the cardiologist, Dr. Othman, say where an operation is to be performed. So in our view, there's no breach of the standard of care with the failure to recommend surgery elsewhere. And he went on to admit that he could not state more likely than not whether the patient's outcome would have been better had the surgery in fact been performed at this major medical center. He gives kind of equivocal testimony that the outcome of resuscitation might have been better. but he can't say it to a reasonable degree of medical certainty. He deferred to other experts when he was asked what advanced resources would have been available at a different center that weren't available at this outpatient center. So it's speculative and in fact impossible to say that if Dr. Othman had made the recommendation to the eye surgeon, Dr. Watson, that she would have performed surgery at a major medical center or anywhere except this one facility that she had privileges at. So what the trial court did is that was not the only theory that we challenged in our motion. We challenged multiple breaches of the standard of care, but the trial court got confused between the theories and found that there was causation as to the breach that was premised on the need for additional testing and precautions. But that's a different theory than the failure to recommend the surgery be performed elsewhere. So on appeal, we are just challenging that one narrow theory of the failure to recommend the surgery be performed elsewhere. So all of the findings of causation and all of the mentions in the plaintiff's brief of, well, there's causation as to, the discontinuation of the antiplatelet drugs, the need for additional testing, none of that has to do with this theory of the recommendation. So it is speculative to say that a surgery at a larger institution would have avoided the event, this bradycardic event and the resulting brain injury to the plaintiff. Again, no one identified what advanced resources would have been present at a larger facility and how they more likely than not would have prevented an adverse outcome.
So counsel, how granular do we need to get for there to be a question of fact here about these, you have, links of causation and all that sort of stuff. And I understand you're saying some of those, aren't as substantiated as they could be, but how do I know that tips from just, maybe not being a very convincing case to being one that fails as a matter of law?
Sure. Well, the expert himself got granular because when we asked him, well, you say more advanced resources, what do you mean by that? He could have said any number of things, but he said an electrolyte panel, which is the anesthesiologist's responsibility. And he admitted that he doesn't know if an anesthesiologist would have ordered it or if it would have prevented this incident. Then he was talking about the ECMO machine, which is where, your blood is basically circulated outside of your body to oxygenate it. He doesn't know if she was sufficiently oxygenated. He doesn't know if she would have been a candidate for ECMO or whether it would have prevented her death. And then he just said, well, they would have had more information about his condition, about her condition, but he didn't identify what information. So he's the one that went into the granular detail about what would have been available at this major medical center that the outpatient surgery center didn't have. And then he failed to support, he deferred largely to other experts when they said, well, what other advanced resources would have been available and how would that have changed the outcome? He said, well, I'm just the cardiologist. I don't resuscitate people. I'm going to defer to other experts. And that's at pages 134 to 135 of his deposition. So he had the opportunity, and plaintiff had the opportunity to flesh that out and substantiate it at the summary disposition stage, but they can't proceed to trial just on a vague causation of, well, the result would have been better because there's nothing to substantiate that in his testimony or in the testimony of any other experts. So for that reason, we think that there wasn't sufficient evidence of causation to avoid summary disposition on this theory, plus the impossibility of even being able to perform it at a major medical center. I'll reserve a few more minutes for rebuttal.
Thank you, counsel.
Good morning, Kirsten Reinhold on behalf of Plaintiff Appellee. We would argue that the trial court correctly denied summary disposition and correctly determined that Dr. Fintel's causation testimony regarding a recommendation to a major medical center was not speculative and was significantly related to Dr. Othman's failure to classify Elizabeth as a high cardiac risk. There is a logical sequence of events showing that Elizabeth, more likely than not, would have had a better outcome if Dr. Othman had properly managed Elizabeth's decreasing heart function during the entire cardiac clearance process. This includes first classifying her as the correct cardiac risk level, second, proper medication management, and third, providing the best recommendation for a surgery location for her best outcome. The trial court determined that the classification of cardiac risk and the proper surgery location recommendation are inextricably linked. And this is based on Dr. Fintel's testimony. He testified that Elizabeth was improperly classified as an intermediate risk when she was actually a high risk, and she was a high risk to the degree that she could have deteriorated at any time due to the anesthesia and the surgical manipulation due to her extensive kidney and heart conditions, specifically with the left ventricle. And if she had been properly classified as a high risk, then she would have been put under stricter scrutiny perioperatively. She would have had further testing done. She would have also had her medications managed in a completely different way. So start to finish, the classification of her cardiac risk is linked to the ultimate location of where the surgery needs to take place. And because she was a higher risk, that required a place with more devices such as ECMO, which Dr. Fintel testified to. And she did ultimately pass from anoxic encephalopathy, which is lack of oxygenation to the brain. So that kind of shows, per Dr. Fintel's testimony, that an ECMO device could have helped her, as it kind of functions as your lungs and heart to oxygenate the body.
So, counsel, what's your specific response to, I guess, opposing counsel's point that there's nothing in the record to substantiate what would have been better at a different facility?
Well, I think Dr. Fintel actually did testify to this. On page 131 of his deposition, he spoke about an urgent angiography would have been available had this been conducted at level 1 trauma center, mechanical surgery, circulatory support, including ECMO devices, immediate responses to testing from labs, because the lab would be internal rather than at an outpatient facility where they have to send it out, wait who knows how long, and then eventually get it back. You can't get that immediate response during surgery that you can at a level 1 trauma center, as was recommended. So if there are no further questions, then I would rest. Thank you.
Further.
I think at the end of the day, it doesn't matter what Dr. Fintel said about other resources, which he didn't say that he could show of it. He deferred to other experts on the other resources. This eye surgeon could not perform the surgery at a major medical center. If the plaintiff had showed up at a hospital, she would not have gotten the surgery because this surgeon was not privileged to perform any surgeries at a major medical center. So I think that completely cuts off the chain of causation that has to do with recommending the surgery be performed somewhere else, because as I pointed out earlier, there's no allegation that my client, the cardiologist, even if he had assessed her at high risk, should have found her a different ophthalmologist who had privileges at a major medical center. He agreed that the decision about where to perform surgery, regardless of the risk level, is made by the surgeon. The surgeon was not sued. So what more could my client have done to make this eye surgery happen?
If your client had shown that she was a high risk and that recommendation had gone back to the ophthalmologist, then it would have, like, they either would have found somebody who had privileges at the appropriate trauma center or would not have been cleared for surgery, right?
There's no testimony as to that. There's nothing in the record. It seems logical, right? Seems logical that the eye surgeon would have come back and said, well, I can't do this, but there's nothing in the record for that. So this court respectfully cannot supply that logic where plaintiff has failed to make that link, did not sue the eye surgeon and say, look, you should have recognized that this lady was a high risk and not perform the surgery at an outpatient surgery center. So we're stuck with what the plaintiff has developed in this case, and the plaintiff hasn't developed that there was anything my client could have done to make this surgery happen at a major medical center. And so that allegation has to go. So we would ask the court to reverse on that issue. Thank you.
And on to the next one.
Kirsten Reinhold on behalf of plaintiff appellant. The trial court erred in granting defendant's motion to strike certified anesthesia assistant Zagorski and further erred granting summary disposition. Thus, reconsideration was warranted. Cox and Decker indicate that a non-physician expert such as Zagorski must demonstrate familiarity with the standard of care in an area similar to the community in which the defendant practiced in order to be properly qualified. Zagorski's deposition shows that he is familiar both with the local community practice and the type of procedure in a similar community. So the record reflects that he is properly qualified to testify, and summary disposition should not have been granted. And further, the trial court abused its discretion when it denied plaintiff appellant's motion for reconsideration by failing to exercise its discretion and substantively review plaintiff's arguments presented in the motion. We would ask the court to reverse. The record shows that Zagorski was properly qualified. Zagorski and Hathaway are identically credentialed. They both have undergraduate and master's degrees. They sat for the same exact national certification exam. They work in the same or substantially similar localities with similar resources, Metro Detroit, Metro Cleveland. And Zagorski testified he's provided anesthesia services for hundreds of eye surgeries specifically and thousands of outpatient surgeries. So the trial court, in entering its order, focused on testimony regarding mainly the national standard of care that Zagorski testified to and the licensure versus delegatory models in Michigan versus Ohio. But the issue of delegatory authority and licensure authority actually concerns the scope of practice rather than the standard of care specific to the procedure at issue. Under Ohio law, CAAs can perform tasks only as delegated by an anesthesiologist, which per defendant Hathaway's testimony is exactly the same way that CAAs function in Michigan. So there is not a significant difference, though there is a different title for the models. They still function on the day-to-day in the same exact way. They have to answer to the anesthesiologist and can only act as the anesthesiologist indicates. And in fact, Zagorski even pursued his degree in Ohio when Ohio was a delegatory authority state, just like Michigan. So he was educated to understand the model and function under that model. So he would be able to testify as to a delegatory authority state like Michigan. And as to the national versus local standard of care, Michigan courts have found standard of care testimony to be reliable, even when an expert has testified that the relevant standard was a national standard, as in Decker versus Washoviak. The Decker court reviewed the actual substance of the expert's testimony and determined that the procedures at issue were substantially the same, regardless of a local or national standard. The expert in Decker was qualified by testifying to her experience working in pediatric units, as well as comparable available resources where she practiced. So Zagorski's testimony shows he's knowledgeable of the standard of care in a setting comparable to Straith. He testified that he researched Straith to see the types of procedures performed there.
Wasn't that like for 5 minutes before the deposition?
Yes, but I think his testimony also indicates that though it was brief, he has worked in, from what he understood of his research, he understood Straith to be similar to the outpatient facilities that he has worked in. He works primarily in a level 1 trauma, but he also works over the course of his career, has worked in outpatient facilities that he believed based on his review to be similar. He stated he's worked in community hospitals and outpatient facilities, and he stated that he believes that Cleveland is a similar locality, comparable locality to the Metro Detroit area. He testified he's familiar with the specific eye surgery and has performed hundreds of them over the course of his career. So we would ask the court to reverse as he was properly qualified. And then briefly, as to the motion for reconsideration, the trial court failed to exercise its discretion. In the order denying the motion for reconsideration, the trial court stated that the issues addressed in the reconsideration motion were exactly the same issues as presented in our response to the motion for summary disposition. Yet the summary disposition order states that we did not address the delegatory issue, and that so we did not address all of the issues. So there's kind of that logical inconsistency that we would argue.
I mean, could the court have just been sort of speaking shorthand for the general notion that it's not required to reconsider particular arguments that were raised or that could have been raised? I mean, you kind of say it's the same issues that's kind of comprising both of those ideas, perhaps.
Perhaps, I don't know what they were thinking, but from our perspective, I would say that it appeared to be a form order that did not review the actual new case law presented, in the motion for reconsideration. So if there are no further questions, I would rest.
Okay, thank you, Counsel.
Thank you.
Good morning. May it please the court, Michael Cook on behalf of defendant appellee Allison Page Hathaway. The appeal in this matter is strictly from the motion for reconsideration. And it labors on the standard of abuse of discretion, which Judge Mariani just flagged. There is a host of authorities saying that when a issue has been briefed and argued to the court, and then in the reconsideration motion, you're just pointing out stuff that you could have raised before, it's not an abuse of discretion for the court to deny reconsideration. That's exactly what happened here. It was the same issue, the same materials were submitted to the court on reconsideration. They were just pointing to different parts of the testimony that they could have pointed to earlier. So there's not an abuse of discretion. The crux, I think, of the argument on appeal is, and they say it expressly at one point in the brief, is the trial court didn't read the reconsideration motion. I don't think this court wants to say that based on just the context of the order. And I think there's enough there to say that the court didn't err, even if you want to engage that sort of hypothetical. But if that were the case, the result is not for this court to delve into the motion to strike substance. It would be a remand to the court, to the trial court, to say, we don't think you read the motion. You need to tell us you read the motion. And then you have the opportunity to exercise discretion about whether or not you're going to consider these arguments they could have raised the first time around. That seems to be a long circuitous way to do this when it isn't abuse of discretion to deny reconsideration based on issues that could have been argued before that point. In addition to that abuse of discretion standard, the standard for reconsideration showing palpable error. Palpable error is something that's obvious, stands out. There's nothing obvious or that stands out from the ruling on the motion, the original motion. They're relying on things that weren't pointed out to the court. The court's order, if you look at it, is absolutely correct in terms of everything that was pointed out to it in the first round of briefing. The court said Zagorski admitted he failed to conduct any research as to what CAAs in Michigan under a delegatory model are permitted to do or not do. That's absolutely true. Page 22 to 23 of his deposition. Quote, you've never done any research to determine what a CAA in Michigan could do versus what they cannot do, correct? That's correct. So that's not a palpable error. So they haven't met the standard for abuse of discretion review, reversal of a reconsideration denial. They haven't met the standard for palpable error for a reconsideration motion. Anything going beyond the substance of that, I'm happy to address your questions if you have any, but I think it really is right there. If you have any questions, I'm happy to address them.
Thank you, Counsel. Any rebuttal?
Very briefly, I would argue that it is also an error of law, the way that the court applied MCL 600-2955 to this case, which would constitute an abuse of discretion. The entire deposition of Zagorski had been provided during the motion for summary disposition, so all of the relevant testimony had been before the court from the summary disposition stage. And Zagorski testified regarding the delegatory model, his experience with it, his understanding of it, and defendant Hathaway also testified to the delegatory model in a way that is entirely consistent, showing that Zagorski knows what he's talking about and in fact had enough information to speak to it. So if there are no questions, thank you for your time.
Thank you, Counsel.
Yeah.
Okay, those cases will be submitted. Thank you, Counsel. All right, moving on to item 1. People v. Smith. That's case number 371483.
Good morning, judges. My name is Robert Tomac. I represent the appellant Jason Joseph Smith. This appeal presents 4 issues. I want to address the 4th issue because I have a bit more to say about it. This concerns the argument having to do with double jeopardy. This the evidence here established one act, one incident. Yet the court imposed punishments for two separate crimes. One is CSC to second degree, and the other one is the assault intent. Now, if you look at the facts as proven, there was no difference in evidence as to either of these crimes. There was not a attempt to touch regarding the assault. There was a touching. In both cases, there was a touching. The child was under 13, and it was for sexual gratification. Now, right away, we look to Blockberger, and we look at the elements, theoretical elements of the crime, and say that one has an element that doesn't have to be proven in the other. But I would submit that Blockberger is a tool to determine the intent of the legislature. There was no discernible intent of the legislature to impose additional separate punishments for these two crimes in this situation. The evidence that there was one incident, I repeat myself, there was one incident, there was, in both cases, there was, as to both crimes, there was touching, and the other two elements, gratification and under 13. So I'm suggesting I'm making a pitch that Blockberger should not be used in every case. That the attention should be paid to the intent of the legislature, and simply looking at the theoretical elements of these two crimes in this situation doesn't establish that the legislature intended for there to be separate punishments. So our argument is that there was multiple punishments under the double jeopardy clause, multiple punishments, and that for that reason it was defective for under the constitutional right against double to be multiple punishments to be opposed for the same crime. So that's my pitch on that issue.
Mr. Tomac, is that an argument that's probably best suited before the Supreme Court?
Yeah.
We're bound by their precedent, correct?
Well, yes. Well, I mean, if the case law does say that it's a tool, and it's there's no law or no case law that says it has to be strictly applied and in every case. And so, I think there's room to argue that the appellate court might not use it in every case. So yes, it's a matter for this eventually for the Supreme Court. The argument is made in issue number 1. This was raised in the motion for directed verdict below that one of the elements being sexual gratification was not present here because of the victim was. The testimony was that the defendant was under the impression or thought that he was dealing with his spouse and that he was seeking sexual gratification from the marital relationship. And so, we present that argument. It was presented below, and we present it to this court. The second issue that we had here had to do with the sentence being disproportionate. This is somewhat moot. My client was paroled last March, but he's got a tail there of 15 years. There was no criminal record for this individual except for a drunk driving ever. And there was no incident, nothing that happened between the 6 years of the incident and the time that it was reported. And there was a recommendation by the MDOC for probation. And so, our argument is that this 2 to 15 was just disproportionate given this defendant. Another argument we have here, issue number 3, has to do with the argument here would be that the jury has to follow the law that the court presents. There's all kind of cases that say that in general terms. And so the instruction was, as to assault, that it has to be a forceful touching of the victim. And the evidence didn't show that. Didn't show that at all. So that's what we have to say on those 4 issues. Thank you.
Questions? Yeah. Thank you, counsel. Okay, that case will be submitted. Item number 2 has been adjourned, so we'll move on to item number 3. That's People v. Keep. Case number 369030.
Good morning, Your Honors. Bretty Groff from the State Appellate Defender Office on behalf of Mr. Kipe. This trial should have been about whether or not Frank Kipe was trying to resuscitate his girlfriend. That was not presented to the fact finder at all. And trial counsel performed deficiently by waiting 2 weeks before trial to engage in any meaningful expert consultation, and by ignoring a challenge to mens rea in his myopic obsession with challenging causation, which the expert that he did consult told him was a dead end. So trial counsel dithered for 6 months, making no progress on finding an expert. And the record is replete with Mr. Kipe doing everything that he can to get his trial counsel to find an expert. He was in court speaking out. He was writing to court administrators, which we made a record of in the Ginther hearing. And the court administrator wrote back and said, "I'm sure that your attorney is on this," but he wasn't. The suggestion that trial counsel consulted 6 experts is completely erroneous. Page 31 of our brief goes line by line to discuss the different things that were suggested, that trial counsel consulted 6 experts. I mean, he was trying to talk about social conversations at parties, and he asked the Oakland County medical examiner, who would have been conflicted out of the case, for a list of people, but he didn't say that but that's not a consultation. He didn't give any of these people the evidence they would have needed to form an opinion, nor did he get an opinion from any of them, except Dr. Mahabir. As to ignoring challenging the mens rea, once trial counsel finally consulted Dr. Mahabir 2 weeks before trial, he failed to ask what the case was about. Was Frank Kipe performing CPR? Dr. Mahabir, in trial counsel's words, shut down the theory that he could challenge causation. And had trial counsel asked Dr. Mahabir if the injuries were consistent with CPR, Dr. Mahabir would have said, yes, they could be. We know that because that's what Dr. Mahabir said in the Ginther hearing. And the notion that this sort of trial counsel posed 3 questions to Dr. Mahabir in a letter when he sent him the medical documentation. And he was relying on this 3rd one that was like, anything else I should know. Dr. Mahabir himself refuted the idea that this catch-all was enough for him to suggest legal theories to trial counsel. Page 34 of our brief, and that's page 38 of the January 17th hearing. Dr. Mahabir said, I cannot read anybody's mind. If they're investigating something or thinking of something or have a question, ask me. Now, the trial court and the prosecution reasoned that because trial counsel challenged causation, he need not have challenged mens rea, and that is a red herring. The challenges are not mutually exclusive. There's no reason that a challenge to causation foreclosed a challenge to mens rea. And Dr. Mahabir told trial counsel that his causation challenge wasn't going anywhere. So for those reasons, trial counsel performed efficiently. Prejudice in this case is I think obvious. In the trial that happened, the prosecution presented Laura Nigro, SS, Dr. Pietrangelo. That Laura Nigro and SS told a factual story. SS's description was a little bit of an outlier, but otherwise, she and Laura Nigro were consistent and they were corroborated by Dr. Pietrangelo. In the trial that should have happened, Laura Nigro's testimony would have been exposed as demonstrably false. All 4 doctors that testified at the Ginther hearing said there is no way that Frank Kipe was on top of this woman punching her 50 times in the face or jumping on her. They all agreed that would have killed her. So Laura Nigro's testimony was demonstrably inaccurate. And that would have colored the rest of her testimony as well. SS's account, contextualized by Dr. Kaufman, sounds a whole lot like CPR. Her testimony is block quoted in the brief, and you can read it. She's asked, and I'm paraphrasing now, but the block quotes are in the brief. She was asked, Mr. Kipe was punching her. No, I didn't say he was punching her. Slapped her. Where did he slap her? On the breastbone. She's describing CPR. It's obvious to anyone who can read it. And the doctors there's a chart in our brief which shows where the doctors that testified agreed and where they didn't agree. But for the most part, all the doctors agreed that you can't know every way someone could botch CPR, and that makes the whole thing pretty unpredictable. Certainly, Dr. Kaufman opined that these injuries were consistent with a botched CPR attempt. Dr. Pietrangelo acknowledged that to whatever extent she was drawing conclusions, they did not account for the fact that the complainant had osteopenia, which made her bones brittle. And the Ginther hearing, there was testimony that not only would that make her bones more likely to break, but break unpredictably. So so more likely that the irregular rib fractures could happen. So that is a completely different trial. That is a trial that never happened. And a different outcome is certainly probable. The trial court's decision really, I think, made several errors on the prejudice analysis. The trial court gave Dr. Kaufman's account little weight because he contradicted the prosecution's witnesses. I mean, that's a little bit of catch 22 if I've ever heard it. I mean, what is he supposed to do? He's supposed to come in and agree with the prosecution's witnesses. That's not going to do him much good. Of course, he's going to disagree with the prosecution's witnesses. That's the entire point. The trial court also erred by not respecting the trial court's role and saying, could a jury believe these witnesses? And if so, how would that factor into the analysis? The trial court just jumped in and weighed all the testimonies and said, here's what I think. That's just legally incorrect. The trial court also failed.
Are you talking about the Ginther hearing or the bench trial?
At the Ginther hearing.
Okay.
At the bench trial, of course, that was the court's role. At the Ginther hearing, its role was to analyze what would be the outcome of a new trial. And a new trial would not be a bench trial. A new trial would be a jury trial. The trial court also failed to understand the importance of proving that Nigro was wrong about the nature of the interaction. At the Ginther hearing, and in the court's written opinion, it said it didn't matter. The court said it didn't matter if Mr. Kipe was punching the complainant in the face because it was the chest injuries that resulted in her death. But when the trial court was making its findings of fact as to mens rea, and after the trial, it sure mattered to the trial court then on page 47 of our brief, we quote the trial court. There's no question in this court's mind that he intended to complete the act of great bodily harm. It's not as if he struck her 1 time, 2 times, 10 times, 20 times, 30 times, 40 times. He struck her over 50 times and jumped on her with his knees at least 10 times. That's an intentional act. The trial court relied on that specifically. And then when it was time to say that's when the court was confronted with evidence that that was demonstrably false, all 4 doctors agreed. Now the trial court says it doesn't matter to him and it wouldn't matter to a jury. That's just legally erroneous. I'll save the balance of my time for rebuttal.
Okay, thank you, counsel.
Good morning, Your Honors. Jack McIntyre appearing on behalf of the people of the state of Michigan. I note that I'm not actually the attorney of record on the case. My P number is P79905. So I'd like to start by addressing the defense argument that the trial should have been about something else. That is using the benefit of hindsight to decide what trial strategy should have been. Mr. Gonix, defense counsel's, the defense's attorney at trial, had to decide on a strategy. And the strategy he adopted was to challenge causation. That was an objectively reasonable strategy to adopt in this case. And that's set forth in page 19 of our brief. I'm not going to belabor those points, but there were risk factors for blood clots. There was a long delay between the attack and the death. There were many good reasons why that was a sound trial decision. And that was at odds to some degree with the trial strategy of arguing that the defendant was attempting to perform CPR or revive the defendant in some way.
How is that tell me how that's at odds?
It's at odds because every single doctor that testified, generally, I mean, it depends on which doctor you're talking about, but generally affirmed that immobilization can, in fact, it is a risk factor for a potentially fatal blood clot. The victim in this case died of a deep vein thrombosis. The cause of death, according to the medical examiner, was immobilization due to the injury she sustained when she was attacked. Every doctor agreed that immobilization is a risk factor for blood clots. If you put a doctor up on the stand, they're generally going to agree that, whether they outright agree with this conclusion that this was the cause of death, that their testimony generally supports that it was the cause of death. So there's a strategic decision that has to be made about, well, are we going to pursue this causation defense and refrain from calling an expert that might undermine that defense, or are we going to pursue this CPR defense that to some degree means conceding something regarding causation? And just by way of illustration, if defense counsel had done the opposite, if he had called Dr. Mahabir and Dr. Mahabir said, yes, I agree that the cause of death, that the defendant caused the death because the blood clot was a result of the injuries, we would be right here arguing the same thing. The defense would be saying, well, he was ineffective for not doing this trial strategy. We have 2, you have to choose between them, at least to some degree, choose between them. Defendant's point really is the attorney made the wrong choice about these 2 objectively reasonable defenses. That's not ineffective assistance of counsel. That's trial strategy. And respectfully to Mr. DeGroff, at trial, Ben Gonick did argue that the defendant was attempting to revive Pamela Gaston. He spoke about it actually at page 12 and 13 of transcript 3 of the trial. He did present both defenses, but in terms of his expert testimony, he chose whether to call an expert based on which of those options he thought was the soundest. That is effective assistance of counsel. In terms of this being obvious that the defendant was performing CPR, I strongly disagree with that. One does not slap a person in the face, and this is in the record. One does not slap or strike a person in the face based on performing CPR. And by the way, the testimony is not that these were punches. The testimony was this more something like a closed-handed slap, and this is discussed in the brief. And when Dr. Kaufman was presented with the fact that the testimony said this is more of a slap, it's not a conventional punch where you're hitting somebody with the knuckles of your hand, he said, well, it would be very hard to draw conclusions about that. That's an unusual way to strike somebody. It would cause less damage because there's more flesh. on the palm of the hand than there are on the fists, etc. This is not at all a clear-cut case of any of the doctors agreeing that this was CPR. Some of them admitted that it might potentially be CPR. I do want to discuss Ackley just briefly. Ackley is utterly unlike the incident case. In Ackley, the defense consulted an expert. That expert said there's a widespread disagreement within the medical community about this issue. I adhere to the school of thought. This expert said, I adhere to the school of thought that tends to support the prosecution's argument. I'm not the right expert for you to consult. You should consult this other specific expert. He gave the defense attorney a name of another specific expert who he said was reputable and qualified. And this other expert adhered to the school of thought that supported the defense. There's nothing like that in this case. The doctors testified that there is no broad disagreement about the medical issues of any of the medical issues in this case. It's true that the doctors did disagree on some, specific points in regard to the analysis in this case, but in terms of the medical community at large, there's no broad disagreement that would impact the analysis here. I'll also point out that, the testimony from all these experts, including Dr. Kaufman, said it's hard to say if Niger's testimony was inconsistent with Gaston's injuries. He said elsewhere there was considerable uncertainty about predicting injuries based on testimony. He also said that forensic pathologists were probably, quote, probably the best suited for this kind of analysis. And he expressly stated, it is not our, i.e. ER physicians, it is not our job to say whether injuries are consistent with medical testimony. He also said, how much weight I can put into an eyewitness testimony, that's not my job. He all but conceded that a forensic pathologist is the correct expert to call in this case. And Ben Gonick, in fact, consulted a forensic pathologist. That was a qualified person. There's no argument that he was unqualified. He is qualified. He consulted this person, and this person, he had no reason to think that he had to go and consult another expert except possibly, arguably, Dr. Veeder, because there was some information in the record suggesting that Dr. Veeder might give a favorable opinion. But had he called either of those two people, that would have had no impact on this case. It would not have impacted prejudice. I would point to the trial court's order, which I think is very well reasoned. And Dr. Kaufman, frankly, I don't know how we even get to Dr. Kaufman. How would defense have gotten funding for another expert when he already consulted somebody who was qualified? There was no reason to say we need another opinion in addition to Dr. Mahabir's opinion, aside again from arguably Dr. Veeder. And that's all I have to say right now, Your Honor. Does the court have any questions?
No, thank you, Counsel.
All right, thank you.
Your rebuttal?
Thank you. As to there were several quotes. Further counsel just gave several quotes from Dr. Kaufman's testimony. I can't meaningfully engage with those out of context, but the gist of Dr. Kaufman certainly did not concede that he was not qualified to opine this matter. To the contrary, he did not concede that a forensic pathologist and that he was correct, the correct sort of expert. As to Ackley does not stand for the narrow proposition only that if you consult an expert and they tell you a better expert in the field is available to you, then you have to go do the expert. If Ackley says more than that. Ackley says basically investigate this. It's pre-Ackley, there's United States Supreme Court case law, which says that your investigation has to continue until a defense attorney's investigation has to continue until there's a meaningful stopping point. Ackley expands that principle into the field of looking for experts, and that was one example where the investigation was not complete because the expert told the defense attorney, hey, I'm not your guy, there is another guy. This is like Ackley in that when trial counsel consulted Dr. Mahabir told him, yeah, your theory, the only theory you have, the one you're putting the basket you're putting all of your eggs in is going to go absolutely nowhere. And in trial counsel's words, Dr. Mahabir shut him down should have put him on notice that that was not a winning strategy. As to whether or not trial counsel did make an alternative argument that Mr. Kipe was performing CPR, brother counsel, I guess, cites to 2 pages of the transcript. That is not, I don't know what exactly says on those 2 pages, but that's not a robust and meaningful defense. Certainly not one that includes the corroboration of an expert. And these two theories are absolutely not at odds, that you could challenge causation and mens rea. So it's true that the causation is a little bit eye-catching. It seems odd, but you could certainly think that someone could be trying to do CPR, and all the doctors agreed that when you do CPR, even when you do it correctly, even when a doctor does CPR, injuries can happen. All the doctors agree about that. That injuries from CPR, that there could be causation questions after the fact. And the idea that the mens rea theory couldn't be pursued because then a doctor would be in the mix saying, oh, well, yes, causation could result. The prosecution did that anyway. He didn't get anything by failing to get his own expert to advance the theory of the case.
Counsel, could mens rea only be challenged through an expert testimony?
That isn't the only way it could be challenged, but it was required in this case because the prosecution had an expert who was opining that as a matter of scientific certainty, these rib fractures could not be produced by CPR. And in this way, the case is very much like Ackley, where in Ackley, the abusive head trauma theory is that a certain triad of symptoms automatically means an assault. In this case, we had the same thing, a medical examiner saying this injury means an assault. And you absolutely have to have another expert to say, no, that's not the case. And aside from Dr. Pietrangelo, all 3 doctors agreed, yeah, those rib fractures certainly, more or less, all agreed those rib fractures could result. And furthermore, that her opinion did not account for the complainant's osteopenia, which Dr. Kaufman and other doctors agreed was extremely relevant and important. If there are no other questions, I would just ask this court to vacate and reverse this conviction and remand for the first trial for Mr. Kipe. Thank you very much.
Thank you, Counsel. Okay, that matter will be submitted. Moving on to item number 4, People v. Howe. That's case number 373491.
Hello again, Your Honors. Once again, Brett DeGroff from the State Appellate Defender Office, this time on behalf of Mr. Howe. To prevail, for Mr. Howe to prevail, the evidence in question must be exculpatory, and the police have destroyed it in bad faith. Mr. Howe has always maintained that these were spent cartridges that he was remaking to sell as jewelry and to make chessboards out of. It was undisputed that some of these were in fact spent cartridges that were not ammunition. He had no opportunity to test them and show that they were all spent cartridges because the police destroyed them. The destruction was in bad faith because it was contrary to the department's policies. If it's true, it's always a little bit, cases like this are always tough because the evidence is destroyed. And so it puts the defendant in an extremely difficult position to show that it would have been exculpatory because it's been destroyed.
Counsel, what about the ammunition in the trunk? Wasn't there ammunition found in the center console and then also elsewhere in the vehicle?
My understanding is there were ammunition in different parts. Well, we do not agree that it was ammunition, that there were spent cartridges
Right, understood.
that were remade, that were, remade or had been refilled, but they had been refilled, like not with gunpowder, but with,
And
sand or something like that.
That's for the casings in the, and correct me if I'm wrong, but my understanding is that's for the casings that were in center console, but then there was also, ammunition, to use the term just generally, found elsewhere in the vehicle. Is that not accurate?
I don't believe that to be the case. I apologize if I'm not trying to misrepresent the record. I didn't originally write the brief on this case. I don't believe that to be the case, that Mr. Howe concedes that anything was ammunition. And I apologize if I'm.
That's okay, counsel, understood. Yeah.
Okay. So, so this is always a difficult situation for a defendant to prove that destroyed evidence was exculpatory. And to the extent that the Michigan Constitution could do this different, this is a very narrow avenue where it seems completely reasonable to say, I mean, we have good case law from the Supreme Court saying when a federal rule isn't working, the Michigan Constitution can stretch in new ways to protect our citizens.
Can this court, under the precedent that we have, do that? Or are you playing this argument through to a higher court?
Arguably, yes, and Your Honor, and I'll tell you why. People versus, and this is a little bit of an expansion on the brief written by another attorney, but People versus Salmons, I think it's footnote 7, says it talks about the biggest factors and that those are based on old science and sort of based on predictions, which may or may not have turned out to be true. And the court opines that in that case, when federal rules are not working in the state of Michigan for Michigan specific reasons, then our Constitution can protect our citizens. Coupled with Bauserman, which stands for the proposition that a right has to have a remedy. A right which has no remedy is not a right at all. A remedy is a necessary component part of a right. So if Mr. Howe has the right to challenge the evidence against him, the police can't, and as a blanket matter, should not be able to arrest people, collect evidence. And in this case, this is not evidence of some other thing. The ammunition that's destroyed is the crime, right? The ammunition is not evidence that Mr. Howe did something or another on a different occasion. This is the whole game, is were these things ammunition or not? So they arrest him, they collect it, dismiss the charges, destroy the evidence, and then refile. Whether or not those are for nefarious intentions, that is fundamentally unfair to Mr. Howe. And I think that there is Michigan Supreme Court precedent for the general proposition that our Constitution can expand when the analogous federal rule does not work. Thank you very much.
Thank you, counsel. I see the appellee endorsed, but is the appellee here today? Not checked in. Okay, well then we'll submit the matter. Thank you, counsel. Okay, moving on to item number 5, People B. Wang. That is case number 374474. It appears that the appellant has waived oral argument. Is that accurate?
Correct. So.
Okay. And then we will submit that one on the briefs. That matter is submitted. Okay, moving on to item number 6. This is McCausland v. J.R. Thompson Company. That's case number 373234.
Good morning, Your Honors. Don Van Solicum, appearing on behalf of Marcy McCausland. Ms. McCausland is here today to observe the proceedings.
Welcome.
Your Honor, this is a case involving the dismissal of a 4-count complaint filed by Ms. McCausland. The dismissal was based upon C8 of the Michigan Court Rules. Under the standards, the court must accept the allegations as true, decide solely on the pleadings, and the standard of review is de novo. So I wanted to get those things out of the way right away. It is our position that the court improperly granted the motion, and we should point out that the motion was brought without discovery. The motion was brought without even an answer to the complaint. Now, they have a right to do that, but they didn't have to do it at that time. They could have done it later and turned it into a C12.
But isn't that the point of a C8 motion, to challenge the pleadings right away?
I agree.
Well, then what's the problem? I mean, how is it procedurally incorrect to file a motion?
I didn't say it was
Well,
incorrect.
then, all right, what's the point?
Okay, let me move forward. Let me turn to the 4 counts of the complaint. The one I want to deal with first is the contract claim. Ms. McCausland was a senior executive in charge of financial arrangements for the sale of the company, which sold for $26 million. She was a critical part of that sale. In fact, the buyer wouldn't even buy the business unless Ms. McCausland signed an employment agreement. Ms. McCausland negotiated for an agreement that did not include at will. In fact, when she was presented with it the day before the closing date, she vehemently said, "I'm not signing that. I want a 5-year contract." And her boss, up until 10 o'clock at night on the 8th of December, vehemently said, "You're not getting a 5-year contract." The next day, he relented and said, "I'll give you the 5-year contract." And we looked to the language which was presented at 3 minutes before the deal was to be done. Now, in my opinion, there's nothing wrong with the language that was inserted dealing with the contract. Before, every version before said you're going to be at will, every version. The new version said your employment will be for a period beginning on the start date and ending on December 31st, 2026, the term. Now, one can argue that's a term agreement, but could there be some ambiguity in there? Maybe it's an at-will agreement with just a length of time. But the language that was drafted by the company, not by Ms. McCausland, went on to say, if you remain employed by the company after the term, absent an express agreement providing for such an extension, you will be considered at will. So they are nullifying the right to terminate her at will for the 5-year contract. Now, 5-year contracts are not unusual. Presidents of universities have 5-year contracts. Baseball players have 5-year contracts. Head coaches have 5-year contracts. And if they decide they don't want the coach, they buy out the contract, but they don't terminate them. Now, the only issue that arises here is the fact that the agreement had a provision that appears to be in conflict, but it's not in conflict.
Isn't your analogy to a baseball player? Isn't that the severance that she gets if she's terminated for other than cause?
No, a baseball player would be entitled to the contract term.
Because that's what the contract says.
Well, this contract says
This contract says if we fire you for reasons other than cause, you get 6 months severance as long as you sign the agreement, right?
No, I disagree, Your Honor.
What it says, upon the termination of the company of employee's employment, other than for cause, employee shall be entitled to 6 months base salary. That's exactly what it says.
I understand that, Your Honor, but it's in conflict with the provision that she bargained for. She bargained for a 5-year contract, and during that 5 years, she was not at will.
Well, okay.
I believe that what we have is an ambiguous.
Doesn't the case law say that a term of employment is presumed not to be at will. It's presumed to be at cause, right? For cause.
One could make that argument.
That's what the case law says. That's what
But-
Toussaint and all those
But what,
cases say.
what I'm saying, Your Honor, the argument is that they went beyond just what the case law says. They actually put it in the agreement itself that you're not at will until after 5 years.
Right. And so after 5 years, if they decide to terminate her employment, they don't have to pay her anything. But under the 5-year contract, if they agree, if they fire her for cause, it's okay. But if it's not for one of those reasons, the remedy is, here's your 6 months. So it's not an at-will situation. After the 5 years, it is at will.
But
Why
she
isn't
was
that the correct
terminated-
interpretation?
She was terminated within the 5-year period.
I know.
Okay. But it nullifies everything that she bargained for a 5-year contract, everything.
How?
Because they could have fired her the next day and just offered her severance.
Correct. And
But
that's what the
that's
agreement
contrary
says.
to what she was arguing for, as that she was not an at-will employee. She had a contract for a specific period of time.
Right.
They had no right to terminate her during that 5-year period, except for cause. And that.
Then why
creates-
is there a provision that says if we don't do it for cause, we'll pay you 6 months severance?
Well, that assumes that they had the right to terminate her. They did not have the right to terminate her employment. We believe that at the very least, there's ambiguity in the terms, a conflict between them, and that makes a C8 motion inappropriate on a contract issue. Turning over to the issues of the, excuse me a second here, gender discrimination complaint. We recognize that in Michigan, we're in a notice state. Enough notice to put them on notice of the claims and an opportunity to be able to respond. The complaint is very detailed, went beyond pure notice, and cited a number of things. Difference in treatment based upon gender, humiliation before other peers, difference in denial of bonuses, termination, she's claiming, because of her gender. All of those things raised the specter of a viable claim. What the judge did in this case is made a decision, well, I'm going to evaluate the weight of the evidence and decide that that's not enough to support a claim. Well, you're not supposed to decide the weight. You're supposed to decide whether there's sufficient allegations in the complaint to justify moving to the next step, opening the door and allowing for discovery. And then if at a later point, you always have the right to have a C10 motion.
What were the allegations that comprised a hostile work environment claim?
She claimed that it was because of the way she was treated.
How specifically? What did the complaint say? I read it to say that it was her boss's use of the term bean counter, and he sat back in his chair on his desk with his feet up on the desk, and that was causing his genital area to be protruding towards or facing, and that was the two allegations of hostile work environment. Is there more to it than that?
Well, that's what was alleged in the complaint.
Okay,
Your Honor.
so that's what they have to go by.
Right.
The court has to go by what's in the complaint. So those were the two allegations, right?
Yes, Your Honor.
Okay, so is the trial court allowed to then take those as true and determine as a matter of law whether that would meet the threshold required under Michigan law?
Yes,
Okay,
but you have to understand, discovery may show more than what we have. How did he project themselves to other people? She's claiming that this was done because of her, the way he projected himself.
I guess,
Wait,
counsel,
wait.
do you at least need something alleged?
Sorry?
Yeah, I mean, I understood discovery can always show more, right? But do you need at least one allegation that on its own would be legally enough to get you through the door to look for more? Because there's always this line between you can get liberal discovery, but you can't go on a fishing expedition. So how do we know which side of the line we're on here?
I believe we're on a sign of allowing it to go to discovery, Your Honor.
But yeah, but why?
On the
How do I know that there's enough in the allegations to get you to that next stage of the litigation, to say there actually is a cognizable legal claim here based on what's alleged, such that you get more, you get to go to discovery.
Excuse me. We have the opportunity to present evidence of how she felt, how she was being treated by him, and her interpretation. And I think that that is sufficient to move it to the next step. The humiliation in terms of, you'd say that bean counter is not humiliating. Well, you talk about a person that has a CPA, master's degree, 40 years of financial
But
experience.
how's that sexual in nature?
Because
A
he
bean
does-
counter is a crack about an accountant. Isn't that what it's,
Well,
a bean counter is someone who counts numbers?
he's not cracking, making jokes about the other male employees.
But it has to be sexual in nature for sexual harassment.
Well, I was talking about gender bias.
Okay, all right, that's different. You're
Yeah,
right
I
at that.
Okay.
Right.
Yeah, I guess that's important to separate. I know you have
Right,
two, gender related claims here. One is
Yeah,
gender discrimination. And I think I understand your argument there. The hostile work environment claim seems to be more, the legal elements seem to be more specific and more, and to require not just a sex-based component, but a sexual related component. And
Well,
I guess number one is that's my understanding of the law.
Well, I think you can have a gender harassment. In other words, harassing a person because of their gender, and perhaps that's the more appropriate.
Without any showing of anything that was done that was sexual in nature. Is that your position? That you can sustain
But we
that?
believe that it was sexual in nature, but I don't believe it was required.
So
we're
what,
not
what
talking
made
about-
it,
we're not
what made it sexual in nature? I guess, what in the allegations? How
Well,
would that?
The allegations of the way he postured himself in front of her, that she took offense to. So, I mean, those are
So
the
that
types of,
one, okay.
yes.
Got it. And is there, and I guess, so that's one way you could potentially sustain your claim, right? Is to show like, this allegation, checks that box at least enough to move forward.
That's correct.
Are you saying that there's another way under the law too for work environment where you don't need any sort of allegation of sexual conduct and you can sustain hostile work environment just based on gender discrimination? Is that your
Yes,
position?
I believe you, well, I believe you can in terms
there-
of, it's hostile, does not have to be sexual. Sexual is the one we always talk about. But if I'm being picked on and made my environment hostile as a woman because of the things that are being done, he's going over my head with my subordinate staff. He's not treating other males the same way that he's treating me in terms of his comments and everything else.
I think that's gender discrimination.
Is that legally distinct from your gender?
Harassment's different.
Okay.
And you have two
No, I
different
understand,
grounds,
I understand, but I think it kind of morphs between the two, I believe. That it's harassment. It's just not, well, our position is it was sexual harassment, the way it was done. But I don't think that we're not talking about someone has to proposition somebody for gender harassment to occur.
But just in terms of the legal analysis,
That's
of
right.
two claims.
That's right.
Okay, understood.
The final one deals with the issue of retaliation. We've made the arguments, we've cited the Supreme Court decisions on that public policy. One, I don't believe that you have to have and go to the Department of Labor because you have a complaint for a loss of wages. The statute says you may go to the Department of Labor. But that's not an exclusive remedy, especially since the remedies provided by the department are maybe different than what are provided in a common law claim for loss of wages. But second, we have a person that complained to HR about the conduct. He was a witness in a trial that Marcy had where he was a defendant. And he was questioned on a number of different things. And he was, as described in the complaint, angry at the end of the deposition and refused to talk to her after that. Now, this is a person that reports directly to him in charge of the major finances of the entire corporation, and he doesn't talk to her. Now, maybe that's not enough. But then it comes up to a time that she is to get a bonus, and she's denied it. No real reason given. And then just before the trial, she's fired. No reason, no cause, she's fired. And it's our position that his conduct and that of the responding at superior, her employer, constituted illegal retaliation. If everybody in this state who files a lawsuit against their employer can turn around and be fired for exercising their rights, that's a violation of public policy. And we believe that that it's justified, set aside the dismissal of the retirement, that retaliation claim, and send it back to the court where we can conduct discovery and we can move forward and get an answer to the complaint. Thank you very much.
Other questions? Okay, you have time for a rebuttal.
Thank you.
Thank you, Councilman.
Morning, Kate Klaus on behalf of the defendants. I want to attack first or discuss first the breach of contract claim. There was no breach here. She was a sophisticated party and she certainly could have negotiated a contract that provided, if I'm terminated within the 5-year term of the contract, you have to pay me out the contract. She could have negotiated that, but she didn't. She negotiated a contract that said, if you terminate me in a 5-year term, not for cause, but for some other reason, you have to pay me 6 months severance. We offered to do that if she complied with her obligation to give us a release, and she refused. So there's no allegation of breach here because my client was not obligated to pay her out a 5-year term. Certainly baseball players negotiate that. Coaches of Michigan negotiate that. If they're fired in the term, you have to pay them out. That's not what this sophisticated corporate officer who chose to negotiate the contract on her own and not secure legal advice did. What she claims is a mistake of the law. She thought that if there is a 5-year term, that meant you got paid out the 5 years if you were fired in between. But there's no case law that says that must be the case. What we have is case law that says you have the freedom to contract and you could quid pro quo any way you want as long as it's not illegal. And there is nothing illegal about our contract.
So counsel, if that severance provision wasn't there and we just had, you have a 5-year term and then after that you're at will. And if she got fired before the 5 years, what consequence? What is she entitled to?
I think if there weren't the payout, the other benefits she got during the 5 years were 5% increases in salary. There were other benefits provided for in the contract other than just that payout term.
Well, I understand, but I'm just saying, I understand this is not the contract we have.
Correct.
But if we had one that just said, you have a 5-year term where you can't be fired except for cause. And then after that, you're at will. And I fire you during those 5 years, during that 5-year term, not for cause. What am I entitled to?
In that case, you would be entitled to the 5-year payout because it says you can't be fired but for cause. If it just said you have a 5-year term.
So you're saying
I
that
think that's
the
different.
addition of the provision in your view overrides that default.
Correct.
And in your view, it's not ambiguous.
Correct. Absolutely not ambiguous. It could not be more clear. And in fact, she signed the document that said, I've read and understood these terms. If there were a 5-year contract that didn't say we can't terminate you except for cause, just here's your 5-year employment contract. We promise to pay you 2 weeks vacation and a 5% raise every year. And then we fired you. I don't think you would be entitled to any severance in that condition because the contract didn't provide for it. In this case, you have a 5-year term. She received benefits under that, including a promised 5% per year raise. And if she were fired in that 5-year term, she got 6 months severance. But I don't think just because there's a temporal term that necessarily and must include severance. You can negotiate for that. And she negotiated for 6 months severance, which is what we offered her, and she turned it down. As it relates to the gender discrimination, the sexual harassment claim, the idea that you need more discovery to know that you worked in a hostile work environment is absurd, right? The plaintiff has to plead facts based on their own experience. This is what I experienced working in this environment. How is discovery going to show any additional light on that? She either was or wasn't sexually harassed, and calling an accountant a bean counter and saying, get out your abacus, just isn't sexual harassment. You cannot.
That wasn't the extent of her allegations.
That was the extent of her allegations for sexual harassment, or for the, sex harassment, was it? Bean counter and get out your abacus. Now,
About the posturing in the chair.
oh, I'm sorry, and that he,
That seems to, you know.
yeah, I apologize. He did lean in his chair or sit back in his chair in a way that she described as aggressive and to show dominance. But that, again, isn't sex discrimination, right? A woman could do the same thing. It's not inherently.
Well, that's
sexual.
not, I mean, I don't think that's dispositive, whether one gender could do it versus the other. I think it's whether there's a, you know, whether it's a, if we're talking hostile work environment, right, it's whether this was done on the basis of sex.
Correct.
And then whether there was there was kind of a sexual component to the behavior.
According to the Corley case, Michigan Supreme Court from 2004, there has to be some sexual element to it. And I don't think leaning back in a chair in a way that somebody subjectively found to be aggressive and domineering necessarily means it's sexual.
But we're at C8.
Correct.
So, you know, we take the pleadings as they are.
You take
And-
the facts as they are. You do
As
not
the-
have to accept her legal conclusion that this was sexual harassment. I mean, if she had said, he looked at me looked me in the eye in a way that made me upset, that's sexual harassment. The court doesn't have to accept that legal conclusion, right? It doesn't. The facts are what they are. She may conclude and pled in this case that it was sexual harassment, but Judge Cohen wasn't bound by that legal conclusion that she made. And on the gender-based discrimination, what she contends is she wasn't invited to golf meetings and at golf events and other social events because she was a woman. She doesn't allege only men were invited. She just alleges that she wasn't invited. But anyway, that's not discrimination, culpable discrimination if it was discrimination, because it didn't really impact the terms and conditions of her employment. She alleges that right up until the time she was fired, she received the salary increase that she was obligated to receive under the contract. And just no allegations that she was treated differently because she was a woman. She complains she says she was treated differently, but she doesn't have that tie in fact that she was treated that way because she was a woman and that only men were allowed to go on the golfing trips and be invited to these interoffice meetings. So absent that, there's no claim for gender discrimination. Again, the court didn't have to accept her legal conclusions, and you need more than just to say, I'm a woman, I was fired, I have a claim for gender discrimination, because everybody has a gender, everybody has a race, and the Michigan Civil Rights Act cannot be construed to be a statutory exemption to the employee at will doctrine. Her final claim for public policy is failed on its face correctly because she needed to have alleged that she was exercising a right conferred by well-established legislative enactment. That's directly from the recent Seagal case based on decades of Michigan law. And the first case didn't involve any claim under the Employee Wage and Benefit Act. It just didn't. We are allowed to bring that complaint to Judge Cohen because under C8, you can bring documents that are publicly filed in the same court. That's what we did. He took a look at it and said, this does not involve a statutory claim. It just doesn't. She pled a claim for breach of contract, promissory estoppel, and unjust enrichment. And because she was not engaged in the exercise of a right conferred by well-established legislative enactment, she did not have a claim for common law retaliation. And if there are no more questions, I'm going to cede my time. Thank you.
Thank you, Council. Any rebuttal?
One of the parts of a sexual harassment claim is not just what is said. It's how it's perceived. A person may not be offended by gross verbal comments about gross behavior. It's in the perspective of the person receiving that information. It can only come from her. And in the complaint, she alleges that she was offended by his conduct, that she felt that she was uncomfortable with it. And I believe that's sufficient. We shouldn't be just saying, well, he leaned forward and that doesn't matter. She perceived it to be important. She perceived it to be hostile. And I think that's the grounds we should be going on.
So her view controls over the courts or the jury's determination of whether what she testifies to constitutes a violation of the law?
She had,
Answer the question.
I'm sorry.
Does a plaintiff's testimony and feelings about what they believe they were subjected to control as to whether it is actually a violation of the law?
Yes, I believe so because.
Really?
it's
So
a-
if she says, I felt like I was subjected to a hostile work environment because of X, and the jury says, well, we believe that's what happened, but under the instructions from the judge, that's not sexual harassment.
We're talking 2 leaps down the road. We're talking about.
All right,
what
so
she is-
let's do the
what she
court.
is alleging,
Okay, forget it.
and
Go ahead, finish up your argument.
what she's alleging in the original complaint is one of the elements of sexual or hostile work environment. If she doesn't perceive it to be hostile, it's, we might always, we might say that there's no claim. But she says it did bother her. It was hostile to her. And that's an important element. It may be that the jury disagrees down the road, but we're not here to judge the merit of what she is saying. We're here to judge whether she's making the allegations, were they sufficient to go to the next step through discovery and an answer. Who knows? Mr. Bellissimo may have admitted that he did these things. It can happen. So I believe that the court improperly rejected the claims, downplayed the claims, and dismissed the case improperly. So we're asking for the cases to be remanded back to the circuit court for trial. Thank you.
Okay, thank you, Counsel. Okay, and that case will be submitted. So that brings us to the end of our 10 a.m. call. We'll take a brief recess for about 5 minutes. 5 minutes. Thank you. Good still morning. Not always the case with our 11 a.m. session, but welcome back. We'll resume our call for the day. We're going to start the 11 a.m. session. I think most folks were here earlier. I won't repeat all of the admonitions. Aside from one, just please be sure, because the proceedings are being recorded and will be posted publicly online. If you have a case that involves minors, or protected or vulnerable individuals, please don't use their individuals' names on the record, but instead, use their initials or other non-identifying information to refer to them. Okay, with that said, we have item number 8, EPS v. NPT 313 Company. That's case number 373915. The appellants have not checked in. Okay, well, we'll proceed with that, Pelly, then.
Good morning, Your Honors. Shelby Avery on behalf of the FLE. Normally, this is where I would ask if you have any questions based on the prior argument, but does the panel have any questions based on the briefing?
I understand your arguments about, unopposed motions for summary and what the trial court, did or didn't say in the opinion, but let's say I accept your arguments about trial court did what was proper under the court rules. But we still have an independent obligation, don't we, to de novo review of the summary disposition ruling? or no?
For so there's two standards of review here. So for the actual, if this was this gets tricky because this appeal is strictly about, it's not about the substance of the actual arguments raised in the briefing. It's strictly whether or not the trial court abused its discretion in rejecting the non-compliant brief.
That's all it is?
Based on the briefing, they were not arguing any of the substance of the actual C10 motion.
Well, that might answer my question there then.
Okay. So panel have any?
I don't think I have any further
Okay.
questions. Okay, well,
Okay, well, I will then rest on our briefing.
yeah, well briefed. Thank you, counsel.
Thank you very
for being
much.
here today.
Yes, absolutely. My pleasure.
Okay, that matter will be submitted. Next up, we have item number 9, which is 2 consolidated cases. That's 373-766, Citizens United Reciprocal Exchange v. Barnes, and 373-770, Barnes v. Raymond.
Good morning, Your Honors. Courtney Evans here on behalf of Appellant Cure. I would just like to briefly address 2 key cases, and we'll reserve any remaining time for rebuttal. First is a Michigan Supreme Court opinion that was just issued in late April of this year. That's Sherman versus Progressive. We submitted a statement of supplemental authority drawing the court's attention to this case last week. As it relates to this case, Sherman makes 2 key findings. First, Sherman reaffirmed the insurer's ability to rescind a policy in cases where the claimant is also the party who made the misrepresentation, and there is otherwise no evidence or no allegations that an insurance company acted improperly. Here, there's no genuine issue of material fact that Ms. Barnes represented 2 key things in her application. She represented that she was the sole driver and the sole resident of the household, and she also represented that she was the sole owner of 2 vehicles, a 2006 Nissan Altima and a 2014 Ford Fusion. There are also no allegations, no evidence in this case that Cure acted otherwise improperly. Sherman also reaffirmed the rule that has been on the books for more than 70 years, that a misrepresentation is considered material if the insurer, quote, would not have issued the same contract had it been given the correct information. That is the case here. Cure would not have issued this policy at all had it known that the Nissan was owned and titled by Ms. Barnes' daughter. And because Cure's underwriting policies don't allow policies where the person who is the owner, the titled owner of the vehicle, is not also on the policy, the premium would have also increased in this case by $263.75 if Ms. Barnes had disclosed that her daughter was a resident of the household and an occasional driver at the minimum of the vehicles, including the Altima, which was by all testimony in this case was Ms. Barnes' daughter's vehicle, not Ms. Barnes' vehicle.
Is there anything in the record about the daughter being a potential driver of the Fusion?
There's no specific evidence of that, but in cases of insurance policies, that is the question, is who is the potential drivers? And because Ms. Barnes' daughter lived at home when she was home from school, she was technically still domiciled in the house, and she could have driven either vehicle. You know, she's home from college for the summer. She needed to go run some errands. She could have just as well hopped in her mom's vehicle. There's no testimony that she was barred from driving or she was forbidden from driving, or there would be no circumstance under which she would have driven. And that is something that Cure specifically would need to take into consideration when deciding the premium, when deciding to issue this policy, and they were not given the opportunity to do so.
So I guess is your point then that the evidence of the fact that she lived in the household just by itself is enough to kind of lead to the sort of general status as a potential driver absent something otherwise?
Yes, that's correct. And that seems to be consistent with what the Michigan Supreme Court has found in other rescission cases where there have been individuals living in the household who have not been disclosed. And that just increases the risk that needs to be contemplated in the policy as a whole. And that is why courts have allowed insurers to rescind policies in similar situations. The second case I'd like to discuss is the case that was relied on by both appellee and the trial court in denying summary disposition in this case, and that's Howard versus LM General Insurance Company. Howard involved an insurance policy that was initially issued to cover several vehicles, including a Mercury Mariner. A few weeks before the accident in Howard, one of the insured parties who was not the injured party, she contacted the insurance company, asked them to cover a separate vehicle. That's the Yukon, was adding a GMC Yukon to the policy. And the Court of Appeals found that the misrepresentation regarding that separate Yukon vehicle that was later added to the policy was not material as it involved a separate vehicle. And this is what the trial court really latched onto from Howard, is that Ms. Barnes' misrepresentations were similarly not material because they involved a different vehicle, because they did not involve her daughter's Altima. They involved only that 2014 Ford Fusion that was Ms. Barnes' vehicle. However, Howard did not require this kind of piecemeal approach to insurance policies, where if you have two vehicles and one of them there's misrepresentations about, and there's, you know, this type of approach that would allow you to kind of reform a policy to only look at one of those vehicles versus the other. You have to look at the insurance policy as a whole. And that is the standard, is that would the insurance company have issued the policy at issue if they had known the true information? And here, the misrepresentations that Ms. Barnes made as to the residents, her daughter included, and as to the ownership of both vehicles can't be separated from the coverage that she purchased. The amount of risk that Cure assumed was as to both vehicles, understanding that Ms. Barnes was the only potential driver, and that just was not the case. And this would have resulted in a premium increase of, again, $263.75. Howard is also distinguishable because the court found that Ms. Howard, in that case, had no knowledge of the fraud. It was a separate individual who was also on the policy, but she contacted the insurance company and the injured had no knowledge of this. And in this case, Ms. Barnes is the only one that ever made these misrepresentations, so she can't argue that she was unaware of them or is in some case innocent third party. The basic test under Michigan law for a material misrepresentation is that whether the insurer would have not issued the exact contract at issue. And here, Cure would have not issued this insurance policy had it known the true information. So therefore, we ask the court to find that rescission is the proper remedy here, and the trial court should have issued summary disposition based on these facts.
Counsel, let me ask you, so,
Sure.
you know, let's say I agree with you. Let's say summary disposition was warranted on the issue of rescission. Under the Supreme Court's Sherman decision, what comes next? I mean, I understand that it doesn't seem like there's been any equity balancing determination made. And I understand your position that shouldn't make a difference in the ultimate outcome here in favor of your client. But does this then go back for that?
So Sherman found actually that in that case, the trial court similarly had not done a full equity consideration, and Sherman found that that was not necessary because it was essentially a one-sided equity situation where there's been no allegations that Cure acted improperly in any way. The only party that has been alleged to have made misrepresentations is Ms. Barnes. And so the Sherman court found that it would be just a waste of judicial resources to send it back just for an evaluation of the equities when it was going to be a one-sided outcome anyways. There's really no indication here that there would be any finding for the equities in favor of Ms. Barnes.
Okay.
Thank you.
Thank you, counsel. You have time for rebuttal.
Good morning, I think, maybe good afternoon. John Nakis on behalf of Appellee. A couple things I'll remark on and I'm going to answer whatever questions you have. I don't think Sherman really goes into any of the original analysis that you need to make to determine whether or not Howard applies. Howard either applies or it doesn't, and then you would go to Sherman after that. And if you have to get to Sherman, then my position would be yes, it does need to be remanded back down to the trial court for balance of the equities at that point. It might be a one-sided balance of the equities, but at least it should happen. And we should get the record on that, and then we can appeal it or not at that point in time. The other point I was going to make is about a month ago, a panel, which I think Judge Patel was on, issued an opinion, Cure v. Witt, which is 373487. And that's a direct basically re-application of Howard. And in that case, it's unpublished. It was a grandmother owned two vehicles with their grandsons, failed to declare one of the grandsons as the owner of one of the vehicles that was not involved in the crash. In that case, this court held it didn't matter because that vehicle was not involved in the crash. It's not material under Howard. Like any, fraud or misrepresentation as to that vehicle is not relevant. So this whole distinction that the opposing counsel is trying to make about the meeting of the minds issue, like that there in Howard, there was this original contract and then an additional vehicle was added later. In my opinion, Witt is directly on point saying, no, that doesn't matter. All that matters is, was the misrepresented vehicle or vehicle with misrepresented ownership involved in the crash? This formed the lawsuit.
Can you remind me, I'm sorry, I don't know, but the daughter.
Yeah.
She was not disclosed on the application for insurance.
Correct.
That's correct?
Yeah. So
Okay.
Karen is the daughter.
Yeah.
She went back to college in Atlanta in January.
Right, back and forth.
Right. Then mom applies for this new policy at the end of January after she's already left.
Yeah.
The
Okay,
testimony from everyone is daughter stays in Atlanta the entire semester, doesn't come back to Michigan at all. She eventually did end up coming back to Michigan for the summer, but that was not clear when mom was applying for the policy.
I thought the testimony was that she always would come back.
That was the
Great.
testimonies historically that she had,
Yeah,
but
okay.
that there's still like, maybe she gets a job in Atlanta.
But
Maybe
here's
she
the question.
sublets an apartment.
Here's the question, and again, I should have brought it with me, but I remember, and maybe I'm thinking of a different case, because Lord knows there's a lot of no-fault cases, but didn't the cure application, it seemed very broad, if I remember it correctly, that it was, if any relative is ever going to be around, then you need to disclose it. Is that the one, am I thinking the right?
You're thinking of the
Okay,
right one.
so then the affidavit from Cure says, if we would have known that there was this additional risk of the daughter being there part of the year,
Mhm.
The premium would have been higher. Is that not the law anymore, that if once that happens, that the insurer is entitled to rescission? Is that not accurate?
I have two answers for you on it. One is it's a question of fact. I think that there's still a tribal question of fact on was the daughter around at all, and certainly was she still domiciled there. There's a clear question of fact there that the jury should weigh in on. However, to answer the question at this court level, I think you can right now, because the way Howard reads is if the misrepresentation didn't cause an injury in this specific application. So in this case, all that happened was mom gets involved in a crash in the 2014 Fusion.
Right.
They were paid a premium to insure against that exact risk. If it was, if the daughter got in a crash in Atlanta, okay, then we got a different fact pattern. But in this case, it's undisputed. Cure was paid the premium required to insure against the exact risk that happened when this crash occurred.
Counsel, I'm sorry, go ahead.
No, go ahead.
I was gonna say, I understand what you're saying, but how do I know that doesn't belong in the mess of equities that happens after we kind of determine as a matter of law that rescission is an appropriate
I think
remedy?
it does. It does belong there too. But in order to get to balancing the equities, they first have to prove a fraud or material misrepresentation.
Right, but I guess this is, if you can point me to legal authority that says this would be helpful, and that it seems like the record evidence is that if they had known that there was another household member, the premium amount would have been different. And I understand you're saying that the particular facts of this case don't, implicate the particular individual who is non-disclosed, and that's, I understand that, but nonetheless, you still are paying one premium for a policy. And they're saying that premium for that policy would have been different if we had known that there had been this other individual in the household. So why is that not enough as a matter of law to at least say rescission is in play, and now we go to equities?
So as far as I know, there's not a directly on point case for that issue. All that we have is Howard and Witt, which are about vehicles. They're not about people in the house. That being said, I still think that you can get easily from Howard to this issue of there was no injury to Cure in this case. And the reason there was no injury is, yes, there was fraud, and there was fraud in Howard too. Everyone agrees there was fraud done. There was a material misrepresentation. but there was no injury. The fraud, or to put it another way, the fraud itself was not material to the crash that then subsequently occurred. So it's more looking at the realities of what happened versus getting hung up on, okay, everyone agrees there was a fraud.
But isn't the materiality question not about whether it was material to the accident, but whether it was material to the premium?
No, Howard is very clear. And Howard looked a lot more injury than materiality. Did touch on materiality, but looked at injury. There basically in Howard, there was no injury because the car that was misinsured was not involved in the crash. In this case, there was no injury to cure from the fraud because the person that was fraudulently included or excluded in this case was not involved in the crash. So they're not paying her PIP. They're not paying for Karen's PIP benefits. She wasn't there. She didn't even live in Michigan at the time.
Wouldn't their injury be, though, the amount of premium payment that they've lost as a result of the non-disclosure, and that's why they want to rescind?
That might be a whole separate lawsuit where they could potentially sue my client for a tort of fraud and collect the $260 or whatever it is. But in this case, they received a premium to insure Tanitha. She then gets in a crash in a vehicle that they knew about, that she owned, that everything was fine with all of these pieces. They received all the payment they needed to insure against that risk. Then that risk happened, and now they have to provide coverage.
Understood.
Any other questions? Okay, I have one last point that I just have written down is I also would point to a question of fact on the affidavit itself. I know that, we were kind of relevant to what we were just talking about. Allegedly Cure doesn't insure this type of vehicle situation is what they're saying under their guidelines for Michigan. One is it's clear in the case law that you can insure someone else's vehicle. I don't think there's any dispute over that. But two is, I'd be curious to know, we never had the chance to figure it out in the trial court, would Cure have issued two policies, one to Tanitha and one to Karen? What would the premiums difference have been between those two policies? Because basically they're saying, okay, we don't issue this type of policy. Sure, you don't. But if you issued one to Karen, one to Tanitha, what's the money damage difference? And put another way is, I think they would have said that, had we known, we would have issued two policies and the price would have been $1,000 different. They didn't even give us that. They just said, we don't issue this type of policy. I would have liked to know the hypothetical of what would the numbers have been had they issued two separate policies to cover the two different cars. That's all.
Thank you, counsel. Rebuttal?
Thank you. Just a few quick points. First, I want to address the Witt case that opposing counsel mentioned. Our office is very familiar with this case. This is one that we litigated. So Witt does not compel the outcome here. So the only thing that Witt said with regard to Howard is that the misrepresentation must be material to the coverage of the vehicle in question. And in this case, you have a policy that was issued to cover two vehicles, and Miss Barnes' daughter was not disclosed, and that would have affected the premium. And that is all that's required under the law from Keyes, from Ode, from Sherman. All of these cases just show that you just have to show that the policy would not have been issued. Otherwise, Witt was disposed on evidentiary issues that are not at issue in this case. And so you can't draw a direct parallel between those two. And one thing that opposing counsel mentioned that I wanted to bring up is he said, if the daughter would have gotten into an accident in Atlanta, that is why that would have been a different situation. Well, the daughter getting into an accident at any point in what appears to be her vehicle, that's exactly why the failure to disclose her in the policy is a risk that Cure should have been able to contemplate when issuing this policy at this premium. So in this circumstance, as I mentioned in our brief, we have one application, one policy, one individual making the misrepresentations. Therefore, the reasoning in Sherman perfectly maps onto this case, and decision would be proper. We ask the court to reverse the decision of the trial court.
I have a question. What about having to remand it for a balancing of the equities?
Yes, so this paper, I just wanted to draw the court's attention to the direct quote from Sherman. And Sherman said, a remand for the rebalancing of the equities is unnecessary Sherman is the party who committed the material misrepresentations. There are no third-party interests at stake. And as properly recognized by the Court of Appeals, it is undisputed that Progressive did not act improperly. The equities are therefore one-sided, and requiring a remand would be unnecessary. And that's exactly the case we have here. We don't have any indication that the equities would go in any way other than being a one-sided equity analysis, and therefore remand would be unnecessary.
Counsel, I don't have that opinion in front of me. But it sounded like you said for a rebalancing of the equities. And I don't know did I hear you correctly?
You did, yes. So
Okay.
rebalancing of the equities.
So I guess that my understanding is, here we haven't had one just by virtue of procedural posture. And I don't know in Sherman, when I hear that, it makes me think, oh, well, maybe something was balanced in the first instance already. And they're saying we don't need to go redo that. And is that the case? Was there an initial balancing in Sherman?
I do believe there was some balancing. Sherman involved the trial court basically taking the initial policy and
Reforming
it.
Okay,
So
right,
they
right.
reformed the policy. They found that there would be a different policy premium and there would be a refund. And essentially the Court of Appeals rejected that. The Michigan Supreme Court rejected that. So there was some balancing, but it wasn't like this case where you would just send it back down for that. This situation would be similarly unnecessary.
And you may not be able to answer this because it's also an unpublished opinion. But are you familiar with the Walker case that came out? I'm not seeing the date, but sometime this year. And it also dealt with cure. And I think in that case, the panel held that there was no question of fact as to materiality, but remanded for balancing the equities.
I am unfortunately not off the top of my head familiar with that case. We're happy to submit something.
No, that's okay. It's
Let's do it.
unpublished and it just came up in my research. So I didn't know if you had anything to add to that.
We would just
Thank
argue
you.
that Sherman, since it's the most recent controlling authority of the Michigan Supreme Court, that should be applied here. Great. Thank you so much.
Thank you, counsel. Thank you both. Okay, those matters will be submitted. Okay, moving on to item number 10, which has a number of numbers, so bear with me. They all bear the name of INRI conservatorship of EJS, or INRI conservatorship of ELS, or INRI guardianship of EJS. And those numbers are 366193, 366194, 368, 675, 368, 676, 368, 677, 368, 679, 371, 489, 371, 490. And I believe we have, there are a number of parties broadly involved. I think there are only two that are endorsed for oral argument. I believe we have Mr. Samuels endorsed and then counsel for Ms. Samuels, if I'm understanding correctly. Okay. Well, we'll move forward. I think, they can all be treated together easily enough, especially with the parties we have endorsed. So I will turn it over to Mr. Samuels when he's ready.
Hello, my name is Jonathan Samuels, appearing in propria persona. These appeals arise from orders entered, the ones that I'm permitted to have oral argument. The orders entered August 2023 after the probate court accepted allegations concerning my conduct as conservator, my reimbursement claims, and my parents' property and finances.
And Mr. Samuels, I do want to assure you that, there's obviously a number of matters here that we're pulling together, and we have, read all the materials on all of them very thoroughly and worked them up very closely. So if there's particular things that you want to direct us to that you think are particularly important for us to be sure we know, please focus there.
Thank you, Your Honor. The central problem is that material factual disputes were resolved without any prior to the August 23rd, 23 hearing, any prior evidentiary hearing, and without meaningful consideration of evidence that contradicted the allegations made by opposing parties. In particular, the freezing of my Fidelity account by an ex parte order June 9th, 23 prevented me from having legal counsel effectively at the hearing on August 23rd. Even though I was entitled to legal assistance as dad's guardian, attorneys wanted money up front, which would then be reimbursed from the state. Having my Fidelity accounts frozen was devastating. I also cited improper service for the August 23rd hearing. I'm asking this court to reverse those orders or remand for further proceedings. Main points were the reimbursement. I personally advanced substantial funds for my parents' benefit. The record contained evidence that I paid significant expenses from my own accounts and advanced money to preserve assets, including dad's Roth IRA. Rather than requiring a complete accounting process and resolving disputed facts through evidence, the court denied reimbursement outright. As I cited, MCL 700-5423 2T recognizes a conservator's ability to advance funds and obtain reimbursements. So that was what led to the $175,000 transfer that I made on January 27th of 23. My position has never been that the court was required to accept my explanation immediately, although I did expect that opposing parties would review the issue with me before criticizing, before the successor conservator moved for the judge to sign the ex parte order freezing my liquid funds. Again, this just was more evidence of the probate court repeatedly accepting allegations regarding property conditions, management decisions, and my conduct, even when I maintained that those allegations were inaccurate. And as at the August 23rd, 23 hearing, I was denied meaningful opportunity to challenge assertions. Where material facts are disputed, those disputes should be resolved through evidence rather than assumptions. So that was what I feel happened again and again in all of these probate decisions that led to my appeals.
Understood.
Were there some questions?
I think I understand your position from your filings.
Thank you, Your Honor.
Thank you.
I understand it. Or pointed out, there are just a number of different cases merged in with this, a number of different grievances merged in with this. The appeal.
I'm sorry, Counsel, can you please put your name on the record again?
Oh,
to
I'm
make sure
sorry,
we get
Bill
it.
Sternberg on behalf of
Yeah, thank you.
The matter before the court, as I understand it, based upon Dr. Samuel's brief, is that the court abused its discretion when it denied his motion for reconsideration on the accountings that he never filed. And that he's claiming that he was denied due process because he wasn't given an opportunity to belatedly file accountings and seek reimbursement. Although the record at the trial court is very clear that he was given multiple opportunities to file an accounting and he just failed to. So what we have, and if the court will indulge me, I can give you the timeline of the accountings which were never filed and which ultimately, when he was seeking his reimbursement of anywhere, I think from 500,000 to $1.5 million, it was undocumented. The judge denied the relief because he didn't advance any proofs.
The council, I think, unless there's something absent from the record, we're very familiar with the record and the timeline, so I don't think you need to go into detail there.
And just as an aside, both the Samuels parents are now deceased. Dr. Samuels filed a claim against the father's estate for the same amount that he's claiming he's entitled to reimbursement on this. That's conservatorship. The 63 days passed for him to file a claim. He did not file a lawsuit. There is a claim pending still that he's got in the probate court. That's still pending. So our position is there's, he sought to overturn the judge's order for denying reconsideration. It's an abuse of discretion standard. And there was no abuse of discretion. He was given plenty of opportunity.
Okay, thank you, counsel. And Dr. Samuels, my apologies. Do you have anything specific in response? And if you do, please, come up.
Your Honor, as you're aware from the record that the accounting for the first year of my conservatorship was prepared and signed by me and by my attorney, and I still don't understand how it was not filed. But then opposing parties had the signed copies. In fact, that's how the final signed copy got back to me. And there was a breakdown that was from other parties. And when given later opportunities in court, opposing parties claim not to have knowledge of the first year accounting. So my point is that that while my final accounting was incomplete, that I had made significant effort and opposing parties had gone over everything with my attorney that I had for the first year. Yeah, it's 18 months. Thank you.
Thank you. Thank you, Dr. Samuels. Thank you, counsel. Those matters will be submitted. Okay, moving on to item number 11. That's People v. Winans, 368-357.
Thank you. I have no idea what time it is, so I will just say good day to the court.
Good day to you, counsel.
Alona Sharon, on behalf of the defendant appellant, Mr. Winans, I understand that Ms. Muggenberg hasn't checked in, although she was endorsed, so I will not save any time for rebuttal. Your Honors, I want to take a little time this morning. I know it's been a very long morning for the court to address some of the case law as it is represented by the prosecution in its brief. Because respectfully, I think it's very troubling how inaccurate the case law is that's contained in the prosecution's brief. And so I will address several of those cases, and I will do it as efficiently as possible, Your Honors. To begin, right, so the first claim is that there's a Brady violation. And the prosecution repeats multiple times through its brief that this Miss Brady, kind of confusing. The witness is Miss Brady, and this is a Brady claim, that
she was available to defense counsel for interview, and so therefore there can't be a Brady violation. There is no case law that says that. The prosecution says that there is. And when you look at the cases that they cite, you realize that that is nowhere in these cases. People versus Davis, they cite 199 Mishap 502, and then a United States Supreme Court case, United States versus Agers, 427 US 97. Agers, I know I'm horrible at pronouncing case names, had to do with the prosecution's failure to turn over the criminal record of the decedent in that case. There is no mention in Agers that a prosecution is not required to turn over exculpatory Brady material if this witness or if the witness is available for cross-examination. There's no.
Doesn't make any sense to argue that.
No. Okay. So, Judge Murray, it's always shocking to me when you agree
I know,
with me
you
because
said
it
that-
doesn't.
You said that
This is the
before, and
second
it
time.
truly upset me when you said
I'm
that before.
I'm so sorry, Judge, but I remember that case.
But whatever.
Okay. So I won't belabor the
But
point.
the good thing is I remember it too, so it keeps me in check.
Thank you, Your Honor. Also, Holtzman and Gilmore, also cited by the prosecution. Those cases were also cited in the motion for new trial. So there's actually a footnote in my brief explaining to the court why Holtzman and Gilmore are misrepresented by the prosecution and are not applicable. So I don't feel the need to repeat that. But perhaps what is the most troubling is the prosecution's representation of Kyles versus Whitley, a very well-known United States Supreme Court case, 514 U.S. 419. It says that Whitley does not extend the people's duty to disclose mere internal assessments or informal conversations unless those conversations contain clear material exculpatory facts that the defense could not have obtained through due diligence. Not true. That is nowhere in Whitley. And in Whitley, first of all, there's a list of things that the prosecution failed to turn over in Whitley. And one of them is an officer's informal notes of a third or fourth interview of the prosecution's star witness. And the court found that it was error to not turn over those notes. So to suggest that the case doesn't apply to notes or that Brady doesn't apply to notes is a complete failure to understand or accurately represent Whitley. But also the prosecution goes on and says in Kyles, it was the cumulative effect of the suppressed statements that was so damaging that if it had been admitted at trial, the weight of the evidence against the defendant would not have been sufficient to sustain a conviction. That is exactly the opposite of what Whitley says. What Whitley says is that is not the standard that a defendant has to meet. And the court in Whitley explicitly acknowledges that even if all of the suppressed evidence would have come in, suppressed in terms of being withheld from the defendant, the jury still could have convicted him. But the magnitude of that information made it such that the court didn't have confidence in the verdict. So to suggest that in Kyles, the magnitude of the suppressed information or evidence would have led to an insufficiency issue is completely false. And it is exactly the opposite of what the court says in Whitley. And I'm very troubled by how many of these cases are misrepresented to this court in the prosecution. Oh, and I'm sorry, there's one more. Referring back to the Davis case that I think Judge Murray understands is, I'm sure all of you understand, is incorrectly characterized by the prosecution. The prosecution also says that Davis held that newly discovered evidence is not grounds for a new trial where it would merely be used for impeachment purposes. Yes, that is what Davis held. It was also overruled by this court in 2012 in the Grissom case by the Michigan Supreme Court, 492 Mich 296. So to the extent that they're relying on that, that was overturned 14 years ago by our state Supreme Court. As it relates to the Brady issue, Miss Brady told the prosecutor information. She expressed she was distraught that this information never came out at trial. And defense counsel, we know, was never made aware of it because the prosecution thinks that they don't have to reveal this information. It is a Brady violation because a large part of the prosecution's case was Miss Springer's running from the home, being terrified, in fear, holding knives. And Miss Brady tells the investigator, she confronted Mr. Winans. She didn't express any fear. She stood in his way. And that very much contradicts the narrative that Ms. Springer gave to the jury. So it impeaches her. It's Brady material, and it is material given that this was a credibility contest. Also, the suggestion that so I'm going to move now to the ineffective assistance of counsel. The first claim being the failure to interview the Bradys, who own the cottage that was rented by Mr. Winans and his lady friend. Again, there's pictures given to the court about how close in proximity the house is to the cottage, right? They're like right next to each other. And he goes out to the property trial counsel, but he doesn't really interview them about the date of the incident. And what we find from the investigator's notes and the offer of proof is that they would have told the investigator, we didn't hear anything. But what we know from Ms. Springer is that the time at which Mr. and Mrs. Brady wake up every morning at 6:30 was like peak prime time of this alleged assault, and screaming and yelling and fighting, because Mr. Winans and Ms. Springer, they don't even go into the bedroom until 5:30. And according to her, for the next several hours, there is this just absolutely crazy fight going on in the house. They're screaming and yelling, and yet the Bradys don't hear anything. And what the prosecution suggests is that, well, this must have been a strategic decision by trial counsel. Yeah, your court has said that it can't be strategic if there's no investigation, right? Something can only be a strategic decision to the extent that counsel has conducted reasonable investigation. There hasn't been any investigation here, none. Even though trial counsel was at the property and Mr. and Mrs. Brady were there, he still didn't interview them. And then the prosecution argues, well, trial counsel must not have asked Mrs. Brady about whether or not she heard any screaming and yelling as a strategic choice. No, he probably didn't ask because he didn't know what the answer was going to be, because he never spoke to Mrs. Brady. You have
Didn't they both, though, both your client and the victim, say that there was an altercation?
100%.
Okay, so then
So-
what difference does it make whether the neighbor heard it?
Because Mr. Winans' version, okay, was that Miss Springer threw a shoe at him
Right?
and hit him in the face. He then threw a shoe back, and then she tumbles over in a drunken stupor, because we know in the morning when the police arrive, she's a 0.19, okay, and slams her face into a piece of furniture. Mr. Winans' telling of the story is not of an ongoing screaming and yelling and that's not Mr. Winans' description. That's Miss Springer's. Miss Springer's description is that he's insulting her, calling horrible names that I don't need to repeat in front of the court, threatening her and all of this, and that it's so loud. That's not Mr. Winans' version. Mr. Winans' version is shoe, and she slams into furniture because she's so drunk and also under the influence of at least
So
marijuana.
that Mrs. Brady's testimony would have been consistent with the version of his altercation.
It certainly would have undercut her version of the altercation. Yes, 100%, Your Honor. Your Honor, I'm not going to touch on the vouching argument. I think that's pretty straightforward. The officer's inappropriate testimony. The failure to impeach Ms. Springer. There is a very beautiful chart in the brief that really tries to delineate statements made in the police report, statements at the preliminary exam, and then Ms. Springer's testimony at trial. The inconsistencies are glaring. Sometimes she's holding 2 knives, sometimes 1 knife, sometimes she has no knives. According to Ms. Brady, there were no knives at all. So and that's just one. The chart is like 3 or 4 pages long. It took quite a bit of time. But I do think it demonstrates respectfully that there was a tremendous amount of impeachment available to trial counsel, and he engaged in none of it. And the prosecution argues, well, he impeached her on the fact that she was under the influence. Okay, that's great. But this is a credibility contest, as Judge Murray has recognized, right? Mr. Winans essentially conceded a domestic violence. He said, yes, I put my hands on her and I shouldn't have, because I tried to move her and I threw a shoe at her. But he certainly didn't concede torture and abuse in the way that Ms. Springer described it. And so to impeach her was critical. That was the number one way to try and prevail in this case, and trial counsel failed to do that. And finally, the issue of the the mushrooms or shrooms. So clearly, at least one juror was interested in wanting to know how this could affect Ms. Springer's reliability, credibility as a witness, because the person didn't understand what the effects of shrooms would be. So I do believe it's ineffective to not present that to the jury because we know, and I think the court can probably take judicial notice of it, it can cause hallucinations and
How can we take judicial, I mean, how can we take judicial notice of what an expert would have said about this case?
I don't think you can take judicial notice of what an expert would have said, but certainly, I mean, the brief.
But that's the claim of ineffective assistance, is failure to present an expert.
Yes, yes, Your Honor, but I do think that judges such as yourself who have experience in these types of things and can know what the effect was. Now, I'm not suggesting
filtering.
I'm not suggesting that after oral argument, you're going in the back and doing shrooms.
But counsel, and I understand your point about the jury note as well, but it seems like the point you're making is that this is something that people should know. So I guess, how does that square with the idea that you needed expert testimony to really meaningfully inform these jurors about the effects of the reliability on her reliability?
Sure, I'm not suggesting that it's something that your average layperson knows, but certainly I think sitting as a judge for as many years, it's something that I think you come across that you would know, just like you would know things about drunk drivings and things like that. But clearly it was something that the jury wanted to know, and it would have been helpful to the defense to demonstrate why, as a witness and as a complainant, she was unreliable and incredible. And finally, the sentencing issue as it relates to OB7. Of course, Mr. Winans was charged and convicted of torture. The scoring of OB7 at 50 points, right, has to be something over and above what would constitute the crime of torture. And there simply isn't anything here to sustain 50 points for OB7. So with that, I would ask the court to either vacate the convictions on the claims of ineffective assistance of counsel, or in the alternative, vacate the sentence because of the scoring error in OB7 and remand for resentencing. Does the court have any questions? Thank you. Judge Murray, always nice to see you.
Nice to see you too.
Thank you, counsel. Okay, that matter will be submitted. So moving on to item 12, it's in re guardianship of HIH 375-229. It does not appear that anyone is endorsed for oral argument on that matter, so that will be submitted on the briefs. Item number 13, in re Sauber minor 378-068, also does not appear to have any parties endorsed for oral arguments. That'll be submitted on the briefs. And item number 14, in re Bowman minor 378-243. That also does not appear to have any parties endorsed for arguments, so we will submit that one on the briefs as well.